Now, the bankruptcies of Chrysler and General Motors have been among the most controversial in recent years, sparking criticism from some investors and attorneys that their fast-track plans trampled on the rights of creditors. Chrysler Group, the name of the new Chrysler, emerged 2 weeks ago, and the new General Motors is set to emerge within the next 1 or 2 months. Greg Miles joins us now to talk about that with Chrysler's lead bankruptcy attorney. Greg?
That's right. I'm here with Corinne, Ball, partner and co-head of the restructuring and reorganization practice at Jones Day. During your 3 decades in the business, Ball has worked on many of the nation's biggest bankruptcies, including Drexel Burnham Lambert, LTV Steel, Dana, and now Chrysler. Corinne, welcome.
Thank you, Greg.
Let's talk about this first. The new Chrysler essentially achieved the sale of its assets within 42 days, emerged almost immediately thereafter. General Motors is making real fast progress too, it seems, and they're a lot bigger. Do you see any barriers at all to them getting out of this thing quickly?
Well, all their objections were filed last week, and looking them over, most of them look very familiar to me. There were 2 that were different, and one of them was the objection filed on behalf of the steelworkers. The United Steelworkers is actually objecting on the theory that the auto workers are being improperly favored over the steelworkers.
This is the retired steelworkers, I think you're referring to.
The legacy benefits for the steelworkers are being disadvantaged.
So what's the big deal with that?
That's not an issue that Chrysler had. That's not an issue that has been previously decided, and I think that the GM team is going to think long and hard about how to deal with that particular issue.
Could this end up being appealed, going to the appeals court, but big enough to go to the Supreme Court, a broad enough legal
You're talking about tens of thousands of steelworker retirees. I think it's something that GM is going to have to think about, and is something we don't have precedent from Chrysler on. So we'll see how they deal with that. The second difference, in Chrysler we were fortunate in convincing our unsecured creditors to support the sale as the best available alternative for everyone. For some reason, the unsecured creditors in General Motors' case are taking a very antagonistic view. And that was disappointing, and I think GM is going to have to deal with that. We did not have that issue.
So what are we talking about here? Could this potentially significantly delay the new GM's emergence?
Well, think about it.
Because they want to get out in 2 to 3 months.
The only fiduciary in a Chapter 11 is the official unsecured creditors committee, and they do enjoy a very special place in the Chapter 11 process, even in 363. So I think we have to listen to their arguments, but their arguments are not novel. So I think GM has the better side of that one, because their arguments are resonating with we should still be able to have product liability claims asserted against the new GM.
Okay, General Motors hopes to sell its assets to the new GM as early as next week, June 30th, or maybe a few days after that. Do you see technically any reason at all why GM might not be able to emerge immediately after that as the new GM once they sell those assets?
If GM succeeds in convincing Judge Gerber to issue an order authorizing the sale, they, I assume, are poised to move forward immediately. However, because they are so large, there will be, I think, a lag of time just for the closing process. And time permits appeals, motions for stay, perhaps even a trip to not only the Court of Appeals, but the Supreme Court once again. So I am sure GM is totally focused on executing that sale as quickly as possible.
Now, you were referring to the 363, which is really the so-called Section 363 bankruptcy, which is a fast-track bankruptcy in which you sell the good assets to create a new company. I wanted to ask you, we've had, in the past 9 months, we've had Lehman Brothers use the 363, Chrysler, and now General Motors. Are we going to see this used a lot more in the future as the weapon of choice by companies to get through fast?
I think it depends on your objective and whether or not there is a third party, either as the provider of new money or the buyer who's really dictating this is the outcome, to do a sale of all or substantially all your assets under that provision of the bankruptcy code. You have to have a compelling story that this is the best alternative. And assuming that were the case, then we're going to see it. I think when there is no credit, Greg, and you have kind of the economy we are all now suffering, of course you're going to see more 363s because there isn't money to recapitalize on a standalone basis.
Yeah, one thing I wanted to just mention, a quick bit of news here, is that we got news from General Motors saying that they have selected the Orion Township, Michigan facility as a key as a Michigan facility as a key site for producing their small car, choosing it over other states outside of Michigan, a key development, obviously, in their attempt to create the new GM around smaller cars. Now, to get back to this 363 or fast-track bankruptcy we were talking about, so does this become the weapon of choice, or under what circumstances do we see a lot more companies using it? Because most bankruptcies, or a lot of them, take 2, 3, 4 years. They're very costly. This is a very attractive, fast-track 2 to 3 month option.
You need a compelling story, and you need someone that is not some third party dictating that outcome, provider of new money or a buyer. So you ask me, where's the new money coming from these days? If new money wants to get out quickly and can create the compelling story that they're not interested in waiting for the negotiations that are anticipated by Chapter 11, and you can make the compelling story, then you'll have a chance of doing a 363. But the legal bar is high.
And one thing to clarify here is talking about this fast-track bankruptcy, as you know, a fair number of lawyers and also creditors made the argument that their rights have been trampled in the Chrysler and also the GM bankruptcy. The most important being is that it went through so fast that they didn't have the time really to assess the value of GM's or Chrysler's assets, and therefore they weren't treated fairly. I mean, isn't that partially a legitimate concern? They didn't have the time to look at it?
I think in Chrysler's case it was not legitimate, given the long history of Tom Lasorda and Bob Nardelli trying to sell the company for close to 2 years. So I don't think it was fair there. But let's put the case back to you. What do we think is going on with all the other auto divisions that are for sale?
But let me step back, though. I want to clarify a point about General Motors or Chrysler, though, is that you've had some academic studies that looked at 363 bankruptcies, and they point out that the value of the new company has increased dramatically over the next few years, which would imply that the creditors are forced to sell out fast, at a discount.
If the creditors can convince someone to come up with new money to fund their alternative, God bless. I think they would have said the same thing 10 years ago when steel failed, when Wilbur Ross made a startling acquisition of LTV and absolutely rebuilt the American steel industry.
Corinne, we got to go.
Okay, thanks,
I want to thank you very much for your time. There you have it, Corinne Ball, partner of Jones Day, talking about GM and Chrysler.